Hello, this is Terrell Sane, and this is a reading of the subpoena that was issued by Jim Jordan to Mark Pomerantz in reference to the case of Donald Trump's indictment in New York City. I'm just going to read the words, no opinion, and there's a lot of people out there that are a lot more knowledgeable about what's going on here than I am, but like I said, my interest is just sharing what is actually included in the document. If you do enjoy this kind of content, please let me know, and I will continue capturing more as I do read these so that I can understand what is going on and what they're responding to. So with that, let's begin. Congress of the United States, House of Representatives, Committee on the Judiciary. Addressed to Mr. Mark F. Pomerantz, former New York County Special Assistant District Attorney, Free and Fair Litigation Group, 128 East Broadway, Unit 793, New York, 1002. Dear Mr. Pomerantz, the Committee on the Judiciary is conducting an oversight of the New York County District Attorney's unprecedented indictment of former President of the United States and current declared candidate for the office. On March 22nd, 2023, we requested that you voluntarily cooperate with our oversight by providing relevant documents and testimony pertaining to your role as the Special Assistant District Attorney leading the investigation into the former president's finances. We received a reply letter dated March 27th, 2023, stating that at the instruction of the New York County District Attorney's Office, you would not cooperate with our oversight. You enclosed a copy of the letter from the New York County District Attorney's Office directing you not to cooperate. The Supreme Court has recognized that Congress has a broad and indispensable power to conduct oversight, which encompasses inquiries into the administration of existing laws, studies of proposed laws, and surveys in our social, economic, and political system for the purpose of enabling Congress to remedy them. Rule X of the Rules of the House of Representatives authorizes the Committee on the Judiciary to conduct oversight of criminal justice matters to inform potential legislation. Congress has a specific and manifestly important interest in preventing politically motivated prosecutions of current and former presidents by elected state and local prosecutors, particularly in jurisdictions like New York County, where the prosecutors are popularly elected and trial-level judges lack life tenure. Among other things, if state or local prosecutors are able to engage in politically motivated prosecution of presidents of the United States, current or former, for personal acts, this could have a profound impact on how presidents choose to exercise their power while in office. For example, a president could choose to avoid taking action he believes to be in the national interest because it would negatively impact New York City, for fear that he would be subject to a retaliatory prosecution in New York City. As a result, the New York County District Attorney's unprecedented prosecutorial conduct requires oversight to inform the consideration of potential legislative reforms that would, if enacted, insulate current and former presidents from such politically motivated state and local prosecutions. These potential legislative reforms may include, among other things, broadening the existing statutory right of removal of certain criminal cases from state court to federal court. The local prosecution of a former president also raises the potential for conflict between the federal law enforcement officials required by federal law to protect the former president and local law enforcement officials required to enforce an indictment and exercise control of him throughout his presence in the local criminal justice system. The committee may consider legislative reforms to address or remedy this potential conflict. In addition, the New York County District Attorney's Office has acknowledged that it used federal forfeiture funds in its investigation of President Trump, including during your tenure in that office and during that time when former President Trump was in office and a candidate for re-election. The committee may therefore consider legislation to enhance reporting requirements concerning the use of federal forfeiture funds or to prohibit the use of federal forfeiture funds to investigate a current or former president or presidential candidate. Based on your unique role as a special assistant district attorney leading the investigation into President Trump's finances, you are uniquely situated to provide information that is relevant and necessary to inform the committee oversight and political legislative reforms. Although the New York County District Attorney's Office has directed you not to cooperate with our oversight, you have already discussed many of the topics relevant to our oversight in a book you wrote and published in February 2023, excuse my word, as well as several public interviews to promote your book. As a result, you have no basis to decline to testify about matters before the committee that you have already discussed in your book or on a primetime television program with an audience in the millions, including on the basis of any purported duty of confidentiality or privileged interests. Your book discloses various details about the New York County District Attorney's Office investigation of President Trump, including internal deliberations about the investigation. Indeed, you discuss how members of the office viewed the credibility of a key witness in the case, and you note that their concern about the case's dim prospects. For example, in your book, you recount a mini revolt that occurred following an internal office meeting on September 21st, 2021, about the investigation into President Trump. You offer details about a disagreement between you and the office's Major Economic Crime Bureau Chief, Juliette Lorenz, about Michael Cohen's credibility as a witness in the investigation. You also complained about concerns expressed by Chris Conroy, the office's investigative division chief, during a meeting on November 12, 2021. According to you, Conroy spoke about his misgivings about the Trump investigation, which stemmed from a recent case involving financial and accounting fraud charges that mirror the charges that the office was considering pursuing against President Trump. That case apparently ended poorly for the New York County District Attorney's Office. Like Lozano, Conroy also expressed concerns about Cohen's liability as a witness. You accused other lawmakers of being relentlessly negative, dwelling on all the difficulties and issues with the case and refusing to acknowledge the positives. During an internal meeting on December 10th, 2021, referring to your colleagues as contentious objectors merely for opinioning that the case was weak and pointing to its many fatal flaws. You ultimately dismissed their concerns about the investigation by suggesting that they were either too lazy to do the work, do not know the evidence, or were somehow afraid of bringing charges against President Trump. Your book, described as a 300-page exercise in score settling and scorn, also reveals the extent to which the New York County District Attorney's Office investigation of President Trump appears to have been politically motivated. Specifically, you describe your eagerness to investigate President Trump, writing that you were delighted to join an unpaid group of lawyers advising on the Trump investigation, and joking that salary negotiations had gone great because you would have paid to join the investigation. You frivolously compare President Trump to a mob boss, John Gotti, and claim that the district attorney's office was warranted in throwing the book at President Trump because, in your view, he had become a master of breaking the law in ways that were difficult to reach. You explained that this collective weight of President Trump's conduct over the years left no doubt in your mind that President Trump deserved to be prosecuted. In other words, As a special assistant district attorney, you seem, for reasons unrelated to the facts of the particular investigation, to have been searching for any basis on which to bring criminal charges. Although you claim that you were able to put aside your personal feelings about President Trump during the investigation, the depth of your personal animosity towards him is apparent in your writing. You wrote of President Trump, "I saw him as a malignant narcissist and perhaps even a megalomaniac who posed a real danger to the country and the ideas that mattered to me. His behavior made me angry, sad, even disgusted." You additionally marveled at the thought of being at the center of what might become one of the most consequential criminal cases ever brought. You reflect on your only similar experience, which you indicated was the indictment of Osama bin Laden and other members of Al Qaeda for bombing the United States Embassy in Kenya and Tanzania. Drawing a parallel between these two vastly different matters speaks volumes about the mindset you brought to the investigation of President Trump. These perceptions appear to have colored your work as a special assistant district attorney, to the point that you even resigned because the investigation into President Trump was not proceeding fast enough for your liking. In your resignation letter, you prejudged the results of the district attorney's investigation, writing that Donald Trump is guilty of numerous felony violations and vowing not to be a passive participant to a grave failure of justice. Your public resignation reportedly left District Attorney Bragg deeply stung and caused him to issue an unusual public statement emphasizing that the investigation into Trump and his business was far from over. Your book also contributed to the political pressure on District Attorney Bragg. Your book also contributed to the political pressure on District Attorney Bragg to bring charges against former President Trump. Accordingly, for these reasons, and in light of your disregard of our earlier voluntary request, please find attached subpoena compelling your appearance for a deposition. Sincerely, Jim Jordan, Chairman. Well, there you have it. That's what he said, and that's what he sent. I'll be looking for the response and be posting that one shortly.